be difficult to understand all this if you don't get it.
My Lords, I hesitate to appear to disagree with the noble Lord Berkeley, but I think I'm... no, but I shall humiliate myself by doing so. I would venture to suggest that there is a definition of private utility in Clause 4 of the Bill, and it's only to be understood in its fullness if read together with Schedule 4 on page 84 of the Bill, which specifies what utility activities are. And I think if one looks at Clause 5 and Schedule 4, one can see what the government is trying to do. But I'm not sure that what the government is trying to do is worthwhile or appropriate. And to that extent, I rise to support the comments of my noble friend, Lady Neville Rove. The background, of course, is that we are starting from an EU procurement directive which applied to the whole of the single market of 27 states, and which needed to take account of the fact that utilities activities in most of those states are provided by arms of the state, effectively, and this applies to most of the utilities activities. Whereas in the UK we have blazed a successful path of privatisation, so that many of the utilities activities that in the other parts of the single market are carried out by the state are carried out here by private companies. And the noble Lord Berkeley makes a very important point when he says that those private companies are subject in nearly all instances to some form of regulation. Before I go further, I just want to draw attention to Schedule 4, which specifies what those activities are. And if I read out the subheadings, which I know are not technically part of the bill, they appear to be gas and heat, electricity, water. Has something been taken out?
I think electricity is later taken out, as I mentioned.
Right, well, water, I'll just work on the text I've got. I mean, what is one meant to do? Water and transport, ports and airports as well, and extraction of oil and gas are also mentioned. But essentially, it's the first few that matter. Can I just say at this point that it's striking to me that the rollout of broadband and the internet and things like that don't count as a utility, because I would have thought they were characteristically matters of examples of a utility, but my noble friend will no doubt be able to give me a compelling rationale as to why they're not included. I come back to the point I made a moment ago about the regulator, though. I read them out because you can see that the activities, my noble lords can see that the activities we're discussing are nearly all of them regulated activities. And of course they are funded by a commitment of private capital, with an assumption that private capital is going to be reasonably efficient in procurement, even just simply for the benefit of its own shareholders. This doesn't preclude, of course, defalcation, fraud, bribery, giving contracts to your best mate. But this bill, as I explained at second reading, my lords, doesn't deal with those issues. All of those issues, if they arose, be it in a public authority or even in a private company, would be dealt with through the criminal law, because they're all criminal offences, and one wouldn't pursue them for a trivial breach of a procedural requirement in this bill. One would go after them for fraud and things of that sort if they were to be taking bribes and all of these other criminal things which are nothing to do with this bill. All of which makes me think, my lords, that really including private utilities here is not entirely appropriate. And that if there were to be, or if it were the case that it was felt to be necessary that the procurement undertaken by private utilities needed some form of statutory control, that it would be better in a separate bill which actually focused on the principles rather than the procedure, allowing the private companies to pursue those procedures that were appropriate to achieving their shareholders' ends, just as we allow Tesco, with the exception of selling cars next door to fruit, for reasons I can't contemplate for a moment why the European Union should take exception to that, but apparently it did. But essentially that we leave Tesco's to decide what procurement processes to follow because they're a private company risking private capital. So that is essentially the ground on which I want to break this point. Now, I will just draw finally, before I sit down, because I know perhaps a little bit more about transport as a utility than I do about have direct experience. I have more direct experience of transport as a utility than I do of the others. I think here there are some distinctions to be drawn, and I take as an example Transport for London, where I served, as noble lords might know, on the board. Transport for London perhaps should be subject to procurement regulations of this character. But then Transport for London is in part categorised as a local government body. That is, it is covered by some local government legislation as well as by its own act. And that might be the rationale for including a body such as Transport for London or some of its other equivalent bodies that have been created around the country. But when it comes to saying that a particular bus company which has been franchised and which, my eyes don't work fast enough, but which, I'm now looking at subparagraph 4 of clause 5, which is the one that captures the activities, that a private bus company, should we say, should be subject to the full panoply of this regulation and lumped in with a body like Transport for London, which is partly an arm of local government, I think goes too far. And I would have thought that a distinction along those lines should commend itself to the government, and that, largely speaking, with the exception of the sort of body like Transport for London I've referred to, at least as relates to transport, the private companies could be removed from the ambit of the bill altogether. But I look forward to hearing what my noble friend has to say, and whether he can explain the rationale and also the question of the internet and broadband, because unless I've mistaken it, it's not in Schedule 4, but where, if it's somewhere else in the bill, I haven't found it. Thank you.
And I'm very grateful to him for expanding very fully on these amendments, but in the case of some of these categories in Schedule 4, there is no regulator who has the power to appoint companies to do things. I mean, ports and airports come to mind. I mean, that'll be probably the government that does that. Are we happy that the government can do that without any sort of regulatory oversight?
Is technically an interruption to my speech. Perhaps it's...
I'm sorry.
No, I'm delighted. It adds much illumination. You could have more of me. But I will simply say that I know nothing about ports, but I do know a little bit about airports. And airports are technically subject to economic regulation by the Civil Aviation Authority. Now, it is true that the Civil Aviation Authority only has, through its own risk assessment, has decided that only Heathrow Airport will be subject to full economic regulation. Gatwick and Stansted are subject to some economic regulation. Most other airports are not economically regulated. That is, they can set their own charges, and if people don't want to fly into their airport, they'll fly to another airport. But it's not entirely true, I think it's fair to say, that where it matters, airports are not economically regulated because they are, and I suppose the Civil Aviation could always reverse its decision if it saw fit, and has the power to expand economic regulation to other airports if it were felt necessary, but I simply add that, and with that I subside and look forward to my noble friend's response.
My Lords, if I may intervene, this is my first intervention